Rights of creditors. Creditors' rights are the procedural provisions designed to protect the ability of creditors, persons who are owed money, to collect the money that they are owed. These provisions vary from one jurisdiction to another, and may include the ability of a creditor to put a lien on a debtor's property, to effect a seizure and forced sale of the debtor's property, to effect a garnishment of the debtor's wages, and to have certain purchases or gifts made by the debtor set aside as fraudulent conveyances. The rights of a particular creditor usually depend in part on the reason for which the debt is owed, and the terms of any writing memorializing the debt. Rights of the creditor when the principal debtor defaults. Upon debtor's default, the secured party can proceed under the UCC or can proceed with any existing judicial remedy. For example, a creditor could simply file a suit to reduce debt to judgment and levy on the debtor's non-exempt property other than the collateral, or garnish, etc. UCC 9-601. Creditor's right to require the debtor to assemble the collateral if the security agreement so provides. The secured party can require the debtor to assemble the collateral upon debtor's default and place the collateral at a location reasonably convenient to both parties. UCC 9-609, c. Creditor's right to render collateral unusable upon default. The secured party can, without removal of the collateral, render the collateral unusable, not damaged, to the debtor. UCC 9-609, a. Some states prohibit this. Creditor's right to pursue the self-help remedy of repossession. Upon debtor's default, the secured party is entitled to take peaceful possession of the collateral without the use of judicial process. UCC 9-609, b. The UCC does not define peaceful possession. The general rule is that if the secured party can take possession without committing any of the acts listed below, the collateral has been taken peacefully. Trespass onto realty. Assault and/or battery, or breaking and entering. Creditor's right to pursue judicial process if the collateral cannot be taken peacefully or secured party does not wish to try. The secured party can secure possession through a judicial petition and hearing. UCC 9-609, b. 1, c. Creditor's rights on disposal of the repossessed collateral. Keep collateral in full or partial satisfaction of the debt, always with debtor's consent. UCC 9-620, a. 1, c. In order to keep the collateral, the following steps are required. Secured party sends notice to the debtor and junior security interests, who gave notice of their claim or have filed a statutory security interest. UCC 9-620, a. 9-621, and the secured party has not received notification or objection from any of the above parties within 20 days after notice was sent. When the creditor must sell the collateral if the collateral is consumer goods and 60% or more of the purchase price, or debt if the collateral was not fully financed by the creditor, has been paid, the creditor must sell at. UCC 9-620, e. Creditor's right to sell collateral. Secured party can always sell. UCC 9-610, a. Time requirement for sale. If objection is received or the secured party must sell, the secured party must dispose of the collateral within 90 days after taking possession. Otherwise, the secured party can be held liable for tort of conversion or, if the collateral is consumer goods, for any loss in an amount not less than the credit service charge plus 10% of the principal amount of the debt, or the time price differential plus 10% of the cash price. UCC 9-620, f. 9-625, c. Reasonable manner. The UCC only requires that sale, lease, or license be conducted in a commercially reasonable manner. UCC 9-602, 7, 9-603, 9-610, a. Sale can be public or private. Secured party must give debtor notice of time and place of disposition, and, except for consumer goods junior lien holders who have given notice of their claims, notice is not required if collateral is perishable, rapidly declining in value, or to be sold on a recognized market, to junior lien holders of record 10 days before notification date. Disposition must be at a reasonable time and place. Secured party can disclaim disposal warranties. Secured party can buy if a public sale, goods are sold on a recognized market or one where there are widely distributed price quotations UCC 9 to 610, 9 to 611. Distribution of proceeds. Expenses incurred by secured party in repossession, keeping, and resale. Balance of debt owed to the secured party. Junior lien holders who have made written demands. Debtor, unless the collateral is accounts or chattel paper, then to secured party unless, to the contrary, provided to the debtor in the security agreement, UCC 9-608, A, 9-615, A. If the secured party receives non-cash proceeds from the disposition, the secured party is required to make a value determination and apply this value in a reasonably commercial manner UCC 9-608, A, 3, 9-615, C. The amount received from a disposition does not in and of itself give grounds that the sale was not conducted in a reasonable manner, however, the price may suggest the need for judicial scrutiny UCC 9-627, A, but see official comments 10 to UCC 9 to 610 and comment 6 to UCC 9 to 615. Creditors' rights to collect deficiency of sale funds from debtor unless the collateral is accounts, chattel paper, payment intangibles, or promissory notes. If the proceeds are insufficient to cover the expenses and balance of the debt, the secured party is entitled to a deficiency judgment, which enables the secured party to get a writ to levy on other property, non-exempt, of the debtor. If the collateral is accounts, chattel paper, payment intangibles, or promissory notes, the secured party is entitled only to a deficiency judgment, if it is provided for in the security agreement. If there is failure of the secured party to conduct the disposition in a reasonable manner or to give proper notice, the deficiency of the debtor is reduced to the extent such failure affected the price received at the disposition. Debtor's right of redemption. If the secured party is not allowed to keep the collateral in possession in full satisfaction of the debt, the debtor or any other secured party has a right of redemption and by doing so can regain possession of the collateral until there is a sale UCC 9 to 623. Waiver. The debtor can waive the compulsory requirement of the secured party to dispose and the debtor's right of redemption only after default UCC 9 to 624.